The foregoing petition is in regards to the current ongoing criminal charge of disorderly conduct and resisting arrest, which are identified in this court under cause numbers 929-0609 and 929-0610, respectively. The plaintiff in this particular matter brought forth is Matthew Reardon, whom hereby petitions for a writ of mandamus and seeks relief from the trial court, trial judge, and ruling made on March 1st, 2021. Plaintiff states that the defendant judge, Mickey Avent, acted outside of his jurisdiction, of his office, and even authority in this particular situation in ordering that the plaintiff cease recording of proceedings brought forth in this court. The trial judge did so, citing Rule 1.03. The trial judge referenced the Uniform Rules of Procedure for Justice Court. Plaintiff stated on numerous occasions that he felt he couldn't get a fair hearing in the Lafayette County Justice Court due to events that have taken place over the past 3.5 years, all stemming from the crippling decisions made in this very court when Judge Carolyn Bell took it on herself to set plaintiff's bond at $150,000 on a felony charge levied against the plaintiff in May of 2017. which not only lacked probable cause, but deprived the plaintiff of his due process rights along with his civil liberties by setting bond in a punitive way, even when plaintiff asserted he had solid proof that he couldn't have possibly committed such crime. Plaintiff had assertively claimed reservations and worries that he had, including recently demonstrating how he feels that he's demonstrated Lafayette County officials and agencies denying the plaintiff of equal protections of the law, which are granted not only by Article 3 of the Mississippi Constitution and its Bill of Rights, but the federal Constitution, which plaintiff swore a lifelong oath to protect and defend. Plaintiff would vehemently affirm before this court that he has remained on the receiving end of repetitive targeting by way of preferential prosecution, which over and over has exceeded the threshold of malicious prosecution and even prosecutorial misconduct. Not only is this blatant to the plaintiff in this cause, but it should be blatantly clear to any onlooker, not only with this cause, but the other open causes filed in this court as well. When all evidence is assessed in November 2020, plaintiff was involved in a case in Olive Branch, where he was charged with contempt, despite doing exactly what he was asked to do by the court. Fortunately, the case was just dismissed on March 1st, 2021 due to plaintiff carrying a tape recorder which corroborated exactly that which the plaintiff claimed. The alleged false arrest is currently on file and pending before the U.S. District Court of Northern Mississippi, referenced by case number 320-CV-00327-DMB-JMV. It is reasons like this that the plaintiff feels it is a paramount need and one that each court should allow. In fact, plaintiff is of the impression that this is a request that should be looked at as an accommodation, and one that's no different than any accommodation afforded to Americans with disabilities under the Americans with Disabilities Act. The trial judge read off the title to 1.03 in the Uniform Rules of Procedure for Justice Court. However, after the title, nothing made sense to the plaintiff, and it almost felt to the plaintiff that this reading was being falsely read and presented to the plaintiff. However, Rule 1.03 states as follows: Use of cameras. The use of cameras, recording, or broadcasting equipment, or such shall be governed by the Code of Judicial Conduct. Plaintiff would state that not only does 1.03 lack any language that would bar the use of an audio recorder, especially in lack of a court reporter/transcriber. This in turn poses prejudicial and completely one-sided to the plaintiff, where everything is left up to hearsay in the absence of proof. Plaintiff requested to motion the court for him to be allowed to audio record the hearing and was immediately denied, further being told something to the effect of, "The rules are the rules." Plaintiff hereby quotes Rule 2.03, additional rules out of the Uniform Rules of Procedure for Justice Court, which states as follows: No rule of procedure, local or otherwise, shall be adopted without the approval of the Mississippi Supreme Court. Plaintiff would request answer from this trial court, and specifically the trial judge, as to if he and this court had approval of the Mississippi Supreme Court to establish such a rule that adversely can affect the outcome of a legal proceeding, and one which is clearly not spelled out in the reference rules of Uniform Rules of Procedure for Justice Court. The plaintiff would then jump down to Rule 3.01, Applicability of Rules, in the same referenced outline. Rule 3.01, Rules of Criminal Procedure in Justice Court, are governed by the Mississippi Rules of Criminal Procedure. General rules are also applicable in criminal cases. When taking a look at the Mississippi Rules of Criminal Procedure, which just so happens to be the true governing doctrine, and examining the facts of this case, it would appear that the rights of the plaintiff on this motion have been affected in a way that could create a material breach of even more entitled rights of the plaintiff. Rule 1.10 of the Mississippi Rules of Criminal Procedure details recordation of proceedings where official court reporters are not provided. Any attorney of record or pro se litigant in a court which does not provide an official court reporter may record or have recorded any court proceeding by audio recording device or stenography. Any expenses incident thereto shall be borne by the party or parties. Plaintiff has attempted to raise multiple instances of irregularities and what would easily appear to be unscrupulous, immoral, and unlawful conduct demonstrated by deputies on site while arrest was made. Plaintiff will not concede his notion that this arrest was a targeted, unwarranted, and further unlawful arrest made with excessive force used, and all for the plaintiff commuting to the Sheriff's Department to communicate his grievances with Sheriff Joey East. Plaintiff has been denied access to the closest camera angle of arrest, which plaintiff wholeheartedly believes is an attempt to hide or cover up wrongdoings and following plaintiff's assertions of not being afforded equal protections of the laws. As such, it is for these reasons listed that the plaintiff believes the idea of a fair and impartial trial is at an improbability and nearing an impossibility to the plaintiff. As such, duress is taken over. The plaintiff respectfully request answer from this trial court and the trial judge, along with a review of such from the Supreme Court of Mississippi. As plaintiff feels as though not having a court reporter, no jury, and no recording equipment potentially paves way to a constitutional crisis and has a habit of removing all fairness from a proceeding that should be comprised of fairness. Plaintiff also requests answers as to why Lafayette County is refusing to produce the closest camera angle of the arrest and parked vehicle despite resistance on the matter. Plaintiff feels that this information is not privileged and is nothing more than the Lafayette County Sheriff's Department and Lafayette County officials yet again attempting to cover their tracks. Plaintiff hereby requests that any and all hearings in this court involving him be pushed back to allow proper response and adherence to request. If this court, the prosecutor, and the state of Mississippi wishes to proceed on with this cause and not dismiss in light of the information brought forth, then plaintiff hereby invokes his right to a trial by jury of his peers, as guaranteed to him by the state and federal constitutions. Respectfully submitted this 2nd day of March 2021, Matt Reardon, the Oxford Outlaw. I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the Sheriff's Department. I'm here at the Sheriff's Department.
Or you will go to jail for disorder.
I'm not being disordered. I'm moving my car! I'm moving my car! I was moving my car! Ah! Really? Ah! I said I was moving my car! Oh! Stop! Ah!